about to get started. Just letting a couple more people in here. We will begin. I've got a couple sort of announcements that I will make before we actually move into introducing our speaker. One is for those of you who are joining us for the first time. The method we use for the Q&A is a sort of moderated Q&A. So when Malcolm is speaking or after he's finished speaking, if you have a question, you can post that either in the chat box for the meeting, or you can send it to me privately if you prefer to do it that way. And I will be asking those questions of Malcolm, so we don't need to worry about people turning on cameras and microphones and any of those potential technical difficulties. We will, as usual, be doing a book draw. You do have to be in Canada for the book draw. And the book was suggested by Malcolm. It's going to be a copy of the book Canada's Founding Debates, which is an edited volume by Janet Eisenstadt. So once our talk starts, I will post a link in the chat box. And if you're in Canada, you can enter to win a copy of that book. And if you don't win, but are interested in the subject of Canada's Founding Debates, that book by Janet Eisenstadt is well worth your time. Also want to let people know that our Freedom Week registration has now opened. Normally Freedom Week is an in-person seminar that we would be doing. But because of COVID restrictions, and even though hopefully we're nearing the end, it doesn't look like this summer are going to be a lot of big conferences going on. So we are going to do an online version of Freedom Week again. It's going to take place during the week of May 31st to June 1st. We'll have 15 different talks taking place over that week. And it is open to everybody and free to attend. And you can attend as few or as many of those sessions as you would like. But if you're a student in Canada and you take part in at least 10 of those sessions, we will give you an Amazon gift card with $100 as a little thank you for attending. Because normally at Freedom Week, we would send you off with an armful of books at the end of the seminar. I will also post a link to that registration for Freedom Week, which includes a list of our faculty and the topics they'll be speaking on, and that'll be in the chat once we get started. With that, I'm going to move into introducing this week's speaker. Really happy to have Malcolm Lavoie join us. Malcolm is a friend both personally and of the Institute for Liberal Studies. He joined the University of Alberta Faculty of Law in 2015, and his research deals with property law, Aboriginal law, and the intersection between private law and constitutional law. We have lots of speakers with good degrees and some people with very fancy degrees, and Malcolm is in that second category for sure. He's got a BA from the University of British Columbia, an MSc in political theory from the London School of Economics, both a BCL and an LLB from the McGill Faculty of Law, and an LLM and an SJD from Harvard Law School. He served as law clerk on the Alberta Court of Appeal and for the Honorable Justice Rosalie Abella on the Supreme Court of Canada. He was also the guest for episode 51 of our podcast, The Curious Task, discussing the question, why are property rights so important? And so if you haven't listened to that episode, I encourage you to check that out. I'll post a link, but you can also find it by looking up The Curious Task on your favorite podcast player. Malcolm is going to be speaking to us this afternoon about Canada's economic constitution. And with that, I'm going to pass it over to Malcolm.
Thanks very much, Matt, for that generous introduction. It's a great pleasure to be here. And by here, I don't mean in my basement where I've been teaching law classes for most of the past year. I mean sort of course, with all of you virtually, discussing some important ideas. So I'm speaking today about Canada's economic constitution. This talk is based on some of the ideas in a book that I'm currently putting the finishing touches on. That book will be called Trade and Commerce, Canada's Economic Constitution, for those interested. So what is Canada's economic constitution? Well, what I mean by that phrase is simply the economic vision that underlies Canada's constitutional order. And so that vision is reflected primarily in the Constitution Act 1867, formerly known as the British North America Act 1867, which sets out some of the basic structural features of our system of government. And there are essentially four components to the economic vision as I see it. Two of them have a decentralizing tendency, and two of them have a centralizing tendency. So firstly, the Constitution is committed to decentralized decision-making through secure property rights. Secondly, the Constitution is committed to local governance, autonomy, and subsidiarity on economic questions. Subsidiarity just means that authority is vested in the level of government that's closest to the people, that is still effective. In other words, there's a default preference for decentralized governance unless centralization is somehow necessary for effectiveness. So those are the two decentralizing features: secure property rights and local government autonomy. At the same time, though, the Constitution is committed to an integrated national economy with secure channels for interprovincial trade. And that gives rise to two centralizing features. So the third feature I identify is federal jurisdiction over economic relations that transcend jurisdictional boundaries, so provincial boundaries, for example, as well as jurisdiction over systemic features of the national economy, such as currency and banking. And finally, the fourth feature of the economic vision is a set of restrictions against erecting barriers to interprovincial trade and interfering with national markets. And those restrictions are primarily directed at provincial and local governments. So the basic ideas that I'm going to be talking about today would, for the most part, have been quite familiar to the framers who came together in the middle of the 1860s to agree to the terms of Confederation. But the economic vision reflected in the Constitution is something that Canadians have increasingly lost touch with. And that includes, unfortunately, lawyers, legal academics, and judges, judges who are entrusted with the responsibility of interpreting the Constitution. And to my mind, nothing better exemplifies the lost understanding of the economic vision of the Constitution than the case of R.V. Como. The facts of the case were simple. A retired steelworker, Gerard Como, tried to bring beer from Quebec back to his home in New Brunswick. By all accounts, the beer was for his own personal consumption. There was quite a lot of it, but I think he was just stocking up and trying to get a good deal on beer. The police pulled Mr. Como over, confiscated the beer, and wrote him a ticket, charging him with possession of liquor not purchased from the New Brunswick Liquor Control Board. Como fought the ticket in court with assistance from the Canadian Constitution Foundation, and he argued that the law that he was charged under was unconstitutional. His argument was based primarily on the long neglected Section 121 of the Constitution Act 1867. That provision reads, "All articles of the growth, produce, or manufacture of any one of the provinces shall, from and after the Union, be admitted free into each of the other provinces." In something of a surprise decision that departed from established precedent to some degree, a judge of the New Brunswick Provincial Court essentially agreed with Mr. Como's arguments. The trial judge held that the provincial law in question, banning all but modest quantities of out-of-province liquor effectively, but that law ran afoul of Section 121. The beer in question, certainly was not admitted free into New Brunswick. In coming to the decision, the trial judge quoted extensively from the debates leading up to Confederation in 1867. And those the sort of excerpts from those debates seem to show that Section 121 was really intended to mean what it said, namely that goods should be admitted freely from one province into another. According to the trial judge, the framers intended that Confederation would bring about a free trade zone within the new Dominion, a fact that should inform the provisions like Section 121. The Como case soon made its way to the Supreme Court. In full disclosure, I should say that I acted pro bono for one of the pro-free trade interveners in the case. When Mr. Como's lawyers reached the Supreme Court, however, they came up against a wall of jurisprudential resistance to the idea that Section 121 should be understood as a robust tool against provincial protectionism. In a particularly interesting exchange during the hearing, Justice Malcolm Rowe made a claim that seemed to encapsulate the approach that the court would end up taking. Justice Rowe said, "Now, you've said to us essentially that Section 121 is an anti-protectionist measure. You know, the Constitution Act 1867 wasn't a document that set out policies. It set out frameworks and competences. Why should we read Section 121 as incorporating a policy? In other words, Justice Rowe was suggesting that the Constitution is basically neutral on questions of economic policy. The idea seems to be that the structural provisions of the Constitution, which are found primarily in the Constitution Act 1867, these provisions provide for flexible and open-ended grants of policymaking authority to Parliament and provincial legislatures without any particular orientation towards one set of policies over another. Unfortunately, this view or something like it seems to have guided the court's ultimate decision in the case. The court ultimately upheld the New Brunswick ban on out-of-province liquor. The court's approach amounted to, I think, a tacit endorsement of the view that the structural provisions of the Constitution, found primarily in the Constitution Act 1867, that these provisions have little to say about economic policy. In upholding the New Brunswick law that Mr. Como was charged under, the court set out a test for Section 121 based on a particularly permissive version of the analysis of whether a law affecting interprovincial trade is within provincial jurisdiction in the first place. Essentially, as long as a measure is rationally connected in some way to a regulatory regime with a valid purpose, it's okay. And requiring only that there be a rational connection to a larger regime with a valid purpose, that's a very low standard. It would only rule out the most clear and overt acts of protectionism, where you could say there's no rational connection to any regime pursuing any purpose other than protectionism. In the Como case itself, the ban on out-of-province liquor was found to be rationally connected to ensuring provincial control over liquor. Sure, it also created an enormous and obvious barrier to interprovincial trade, but the rational connection to a larger regime for the oversight of liquor would have been enough to uphold it. The court's approach in Como is thus aligned with a flexible vision of federalism, according to which regulatory measures from both Parliament and provincial legislatures are to be upheld as long as they have some rational connection to a matter within the government's jurisdiction. This flexible mode of analysis, which only really emerged in the past few decades, serves to facilitate economic regulation from both orders of government, even when the link to a government's jurisdiction is somewhat tenuous. It's an approach that aims to get the Constitution out of the way of economic policymaking, implicitly reflecting the view that the Constitution has little to say about economic issues. While widely held today, the view that the Constitution is neutral on questions of economic policy is wrong, both as an historical matter in terms of the purposes of the document. It's also wrong as a matter of legal interpretation, I believe. And this has implications that extend well beyond the proper approach to Section 121. So I'm arguing here that the Constitution is not neutral on economic questions. In fact, it reflects a sophisticated economic vision rooted in enduring principles of political economy. As I've already indicated, the Constitution endorses an economic order in which decision-making is decentralized in important ways, including both through property rights as well as provincial jurisdiction over matters like private law. At the same time, the Constitution aims to secure the preconditions for an integrated national economy, including protections for interprovincial trade and uniform national laws on issues of systemic significance. These policy commitments can be justified in a few different ways. The arguments would include not just the economic growth that an economy structured along these lines promises to deliver, but also political commitments, like a commitment to national unity, as well as the enhanced national security that a vibrant and integrated national economy can provide. And so in the time that I have left, what I want to do is say something about each of these four features of the economic constitution that I've identified. So let's start first with the constitutional commitment to secure property rights. This one may be surprising to some. It's relatively common knowledge that unlike the US Constitution, the Canadian Constitution does not contain a clause specifically requiring that property can only be expropriated for a public purpose and with just compensation. It's sometimes assumed, therefore, that the Canadian Constitution simply does not protect property rights. That assumption is incorrect. The Constitution Act 1867 is in fact quite strongly committed to secure property rights, but the kinds of protections that it employs are those associated with the British rather than the American constitutional tradition. And in that tradition, the British tradition, the principal threat to the rights of the individual is seen to be the executive branch of government. The legislature, by contrast, as well as the judiciary, were seen as branches more likely to protect individual rights, including property rights. And so the constitutional protections for property rights in Canada mainly take the form of restrictions on executive action in the absence of clear and unambiguous authorization from the legislature or a judgment from the courts according to established principles of law. And the main source of these protections is our constitutional heritage from England. These protections can, in fact, be traced all the way back to the Magna Carta, which included a provision that said no freeman shall be deceased, which means deprived of a freehold interest in land, except by the lawful judgment of his peers or by the law of the land. By the 18th century, English courts had developed firm limits on the power of the executive to interfere with property rights, except in cases involving the defense of the realm. It was established that the Crown had no authority to interfere with vested property rights, except where that authority had been clearly and affirmatively granted by Parliament. It thus became established that both taxes and acts of expropriation required clear authorization from Parliament. These constitutional restrictions, it's important to note, this was as far as English courts could go in protecting property rights while remaining consistent with the idea of parliamentary supremacy. If Parliament can do anything, then the furthest you can go in protecting property rights is to require that any interference with those property rights must be clearly authorized in legislation. And these protections were incorporated into Canadian law, in part, we can say, through the preamble to the Constitution Act 1867, which says that Canada will have a constitution similar in principle to that of the United Kingdom. And that included the restrictions on executive power that had been developed in the English constitutional tradition. But the framers actually also went further in reinforcing these protections explicitly in the text of the Constitution, particularly under the legislative power heading of the Constitution Act 1867. So Janet Agenstadt has argued recently these provisions were intended to protect property rights in keeping with the philosopher John Locke's vision of a legislature that must consent in the name of the people to infringements of property rights. So for instance, Section 53 requires that money votes, measures for taxation and spending, must originate in the House of Commons. This reflects the Lockean idea that the consent of the people is necessary for such measures. Section 54 then requires that taxation and spending measures must be recommended by the cabinet. The fact that such measures must be recommended by the cabinet reduces the potential for earmarking by individual legislators, which was actually a problem in the province of Canada before Confederation. And earmarking by individual legislators could have the cumulative effect of increasing spending and therefore taxation. And so the combined effect of these provisions and a few others is to create institutional constraints that make it less likely that taxation and spending affecting property rights will be enacted unless they're clearly justified. And as Agenstadt has argued, the regime is basically what one would expect in a Lockean constitutional system in which it's anticipated that the legislature will occupy the important role or an important role as a guardian of property rights. Unfortunately, Canadian courts in recent decades have tended to water down these constitutional protections for property rights. So for instance, by the 20th century, it had become established that the legislature is presumed not to authorize an expropriation without compensation unless it says so explicitly. And so if there's a presumption that if there's a taking of property, the legislature intends for there to be compensation unless it says otherwise. And that rule was interpreted to include cases where the government regulates property to such a degree that an owner is effectively deprived of the property. In those cases too, it was assumed that compensation was to be provided unless the legislature stated otherwise. And so if the government took property directly or indirectly, the idea was that compensation was the default outcome unless there was a clear statement from the legislature saying no compensation. But in a 2006 case, the Supreme Court revised its approach to so-called regulatory takings or de facto expropriation. So now in cases where the government has regulated away all profitable uses of property, it usually does not need to provide compensation, even without a clear endorsement of that outcome from the legislature. So even if the legislature has not clearly authorized an uncompensated expropriation, it can effectively take place through regulation, I should say. Similarly, courts in recent years have taken a permissive approach to the requirement that taxation measures must originate in the House of Commons. Courts have allowed for relatively vague delegations of taxing power to the executive or administrative bodies. This is an issue that recently came up in the carbon tax case at the Supreme Court of Canada. Delegated taxing power of just about any kind is arguably inconsistent with the text of Section 53, as I believe Peter Hogg has previously argued. By allowing for delegated taxation, courts have essentially diminished one of the key protections for property in the Constitution, which is the requirement that taxes have to be authorized by the people's representatives in the House of Commons, or in the Legislative Assembly of a province. So that's the first feature, the commitment to secure property rights and how courts have started to lose touch with it. The next important feature of the economic constitution is the commitment to decentralized governance on economic questions. In addition to the decentralization of decision-making provided for through property rights, the Constitution also provides for decentralized legislation and administration on economic questions. Indeed, the division of powers between the federal parliament and provincial legislatures reflects a commitment to economic subsidiarity, or subsidiarity on economic questions. And subsidiarity, again, is the idea that decision-making should be made at the level closest to the people that is also effective. In essence, there's a presumption in favor of local decision-making, except where there are special reasons to believe that centralization is necessary in order to be effective. The cornerstone of provincial economic jurisdiction is the power over property and civil rights, which is a constitutional term of art that's long been understood to presumptively encompass all of private law. Private law refers to the laws that govern relations among private parties, in contrast to public law, which governs relations between the state and its citizens. Private law includes property law, contract law, as well as what at common law is called tort law. Essentially the full body of rules that govern the relations among private parties, including their economic relations. From the perspective of constitutional history, the main reason that private law is presumptively under federal jurisdictions, that there are private law is presumptively under provincial jurisdiction. There are federal exceptions, which we'll talk about in a second. But the reason for that presumptive provincial authority historically was primarily the distinctive civil law tradition in Quebec. Indeed, the term property and civil rights is the very same term that was used in the Quebec Act 1774 to restore private law in Quebec following the conquest. The significant autonomy accorded to the provinces is protected by the principle of jurisdictional exclusivity. This is the idea that set out primarily in sections 91 and 92 of the Constitution Act 1867, that areas of jurisdiction of the provinces and the federal parliament are mutually exclusive. If a matter is under provincial jurisdiction, that automatically means it's not under federal jurisdiction, and vice versa. And so that's important to protecting this local autonomy that we're talking about. The federal parliament also has important areas of economic jurisdiction, but as I'm going to argue, these are on issues where local regulation would not be likely to be effective, such as with respect to interprovincial trade or systemic features of the national economy like currency and banking. One of the challenges in a constitutional order committed to protecting local autonomy is how to prevent it from being eroded over time by a central government taking a larger and larger understanding of its own jurisdiction. This is essentially what has happened in the United States, where the Interstate Commerce Clause has been interpreted to allow Congress to regulate almost everything, not quite everything, but almost everything. And since valid federal laws take precedence over state or provincial laws in both the US and Canada, any growth in federal jurisdiction effectively means that local decision-making comes to exist at the sufferance of the central government. And the principal mechanism that we have in the Canadian Constitution to avoid this happening is the exclusivity principle. The text of the Constitution repeatedly states that the areas of federal and provincial jurisdiction are exclusive. There is not meant to be any overlap. Indeed, the Constitution repeats this to the point of redundancy. In practice, some degree of overlap is inevitable in the sort of pragmatic art of lawmaking and governance. So there's some degree of practical overlap that has to happen. But the text of the Constitution does instruct courts effectively to police that overlap with vigilance. And this should result in keeping both federal and provincial laws within their own bounds, which has the effect of protecting local decision-making from federal overreach. The problem is that in recent years, the Supreme Court of Canada has come to abandon the principle of jurisdictional exclusivity, or watertight compartments, as they refer to it pejoratively. Instead, there's been a move to a flexible, sometimes they say cooperative conception of federalism. The federal and provincial heads of power are given a generous interpretation such that they overlap considerably. For instance, laws are able to intrude on the jurisdiction of the other order of government as long as they're rationally connected to a broader regime otherwise within a government's jurisdiction. Again, rational connection is a very low standard that permits quite a bit. This approach to federalism is a threat to local autonomy, since it expands the scope of federal laws that can take precedence over provincial laws in areas of provincial jurisdiction. And this approach may have an impact, for instance, in the assessment of the constitutional validity of the federal government's new environmental assessment legislation. That legislation is grounded in an array of federal heads of power, including the power over navigable waterways and the federal peace order and good government power. But the legislation also extends to some degree into areas of provincial jurisdiction, including notably over natural resources. If that federal legislation is ultimately upheld, it will likely be on the basis of a flexible conception of federalism that allows for legislation partially grounded in areas of federal jurisdiction to extend into related areas of provincial jurisdiction. The move away from jurisdictional exclusivity threatens over time, I think, to undermine the constitutional commitment to decentralized governance on economic questions. One more point before I move on. The constitutional framework providing for presumptive local jurisdiction on most economic questions was initially developed with the provinces in mind. At the time of Confederation, there was not much thought given to the jurisdiction of Indigenous governments. Sadly, this was a time when ideas of assimilation dominated the discussion of Indigenous issues. In recent decades, however, there's been a resurgence in Indigenous self-determination. At the same time, this has, and the growth of the jurisdiction of Indigenous governments, this has presented challenges, including how to reconcile Indigenous jurisdiction with the jurisdiction of the federal and provincial governments. Interestingly, the Constitution Act 1867 provides a compelling model. It provides for presumptive local jurisdiction on most economic questions, while also providing for federal jurisdiction on issues that can't be effectively dealt with at the local level, including interjurisdictional economic relations. And there's no reason in principle why this framework can't be extended or carried over to inform the jurisdiction of Indigenous governments. In fact, it already has to some extent. Presumptive local autonomy makes sense on most issues, particularly in light of the diverse values and concerns of Indigenous communities. But on some issues, like, for instance, a pipeline or an electrical transmission line that crosses the boundaries of many local communities, it may be more appropriate for a matter like that to be dealt with by a centralized authority like the federal government. So those are the decentralizing features I identify: secure property rights and local government autonomy. At the same time as it's committed to decentralized economic decision-making, though, the Constitution is also committed to the establishment of an integrated national economy with free internal trade. And this is where the other two economic features come in. So first, the Constitution accords a positive economic jurisdiction on the federal parliament on economic issues that cannot effectively be dealt with at the local level. This significant but bounded jurisdiction is consistent with a commitment to an integrated economy. Some of the areas of federal jurisdiction are justified primarily by the benefits of standardization, national standardization on some issues. So Parliament has jurisdiction over subjects like currency, banking, and weights and measures. On these questions, it's arguably the case that the benefits of standardization are very large, at least if an integrated national economy is the objective. At the same time, the potential benefits of provincial diversity on these matters are somewhat limited. Another big area of federal jurisdiction, and the one I'll talk the most about, is the various heads of power that relate to interjurisdictional economic relations. This is trade, transportation, and communication across jurisdictional boundaries, including both provincial and international boundaries. Many of the federal heads of power fall under this broad category. And the basic justification for having centralized control over these issues relates to the differing institutional incentives faced by central versus local governments. In setting policy for commercial activity that crosses boundaries, local governments face incentives to prioritize local interests over the interests of parties in other jurisdictions. This natural tendency of local governments is problematic with respect to economic relations with other jurisdictions, since these relations provide particularly ripe opportunities to benefit local interests at the expense of outsiders. So for instance, burdensome regulations applicable only to imports from another province could benefit in-province producers at the expense of producers in other provinces. And crucially, those outsiders who bear the burden or part of the burden of a measure like that, those outsiders are not represented in the government of the local jurisdiction enacting the regulation. So the costs they bear, the cost those outsiders bear, are unlikely to be given significant weight in the local government's deliberative process. In effect, authority over economic relations with other provinces would permit provincial governments to transfer resources from unrepresented outsiders to those inside the province. And while this strategy may seem optimal from the short-run perspective of each local government considering a particular issue, the cumulative effect of local beggar thy neighbor policies like this would be to make sort of all local jurisdictions worse off. And local measures of this nature could also give rise to hostilities among provinces, escalating acts of retaliation, things that would undermine national unity. And so these kinds of economic relations that cross provincial borders are best dealt with at the federal level, where you have a government that is at least more likely to be concerned with interests across the country rather than in one specific locality. So the federal government the federal parliament, I should say, has clear jurisdiction over interprovincial trade. Part of the problem has been, with respect to barriers to interprovincial trade, part of the problem has been that the federal government has been reluctant to exercise the authority that it has. And so interprovincial trucking is one example. Because this area has been largely left to the provinces, you have the problem of differing standards from one province to another, which can in some cases require trucks to change configurations when they cross a provincial border. At least that was the case until relatively recently. Haven't checked it in the past couple of years. An area like that cries out for a positive exercise of federal jurisdiction to create uniform rules, right? That's an issue that can be solved by the positive exercise of authority by the federal parliament. Something with respect to interprovincial trade that I think the Constitution clearly allows for. Finally, the fourth feature of the economic constitution is the set of restrictions, or the set of restrictions, I should say, on barriers to trade and other interferences with economic integration. This brings us full circle back to the discussion of Como and the constitutional protections for interprovincial trade. In just about any federation that's committed to economic integration, you need to have rules that limit the ways in which local jurisdictions can interfere with the flow of trade in national markets. Otherwise, you're left with what is essentially a collective action problem. The local jurisdictions might like the idea of free trade in the abstract, but when they're presented with specific opportunities to favor local producers at the expense of outsiders, the simple fact is that people in other provinces who are affected don't have a voice in the provincial government. And that's going to be a difficult temptation for local governments, provincial governments in this case, to avoid this temptation to favor insiders at the expense of outsiders. So local protectionism is a built-in problem in a federal system of government. And it's one that all federations have to address one way or another. The United States, Australia, and the European Union all have robust constitutional rules that limit the ability of local jurisdictions to discriminate against goods from other parts of the federation. Canada's constitution, too, has built-in mechanisms to limit provincial interference with interprovincial trade and national markets. And these take essentially two forms. Firstly, the division of powers between Parliament and provincial legislatures places important restrictions on the jurisdiction of the provinces. Many of the potential forms of interference with interprovincial trade are by their nature within the exclusive jurisdiction of the federal parliament, meaning they're outside of the competence of the provinces. Recall that the division of powers between parliament and provincial legislatures is based on a principle of mutual exclusivity. The powers assigned to parliament are necessarily denied to the provinces. This means that the federal heads of economic power have an important negative dimension. Yes, they grant power to parliament, but at the same time, they deny power to the provinces. For some heads of federal power, the denial of provincial authority has particularly important implications for internal trade. So for instance, under section 91(2), Parliament has exclusive jurisdiction over interprovincial trade. That means that provinces do not have jurisdiction that extends to interprovincial trade. So in principle, that rules out a lot of potential acts of provincial protectionism. If the primary purpose of a provincial measure is to protect local industry from out-of-province competition, for instance, then the measure likely relates primarily to interprovincial trade, and so is outside of provincial jurisdiction. Similarly, several federal powers together grant exclusive jurisdiction to Parliament over interprovincial transportation. If the primary purpose of a provincial measure is to regulate or restrict interprovincial transportation, say a law that seeks to block an interprovincial pipeline, then it is likely invalid for being outside of provincial jurisdiction. Finally, Parliament has exclusive jurisdiction over indirect taxes. Indirect taxes, that's a somewhat outdated economic concept, but it's recognized to include things like tariffs, excise taxes, and export taxes. And this means that, say, a provincial tax on goods being imported from out of province, a tax like that would be, on its face, outside of provincial jurisdiction. So the exclusive nature of federal jurisdiction creates important restrictions against provincial acts of protectionism. And that was clearly, I think, by design. Unfortunately, these important protections for internal trade are at risk of being undermined by the Supreme Court's trend towards a flexible conception of federalism that allows for considerable jurisdictional overlap between areas of federal and provincial jurisdiction. A flexible approach that enables both orders of government to act in the public interest might sound good, but when you allow for significant provincial intrusion into the federal heads of economic power, you actually tend to undermine an important aspect of the economic vision of the Constitution, the jurisdictional guards against provincial protectionism. I think the move towards flexible federalism is a symptom of a larger problem, that judges simply don't know about or understand the economic ideas underlying the Constitution. So they tend to see things in the text like the exclusivity principle as a kind of weird formalistic fetish that doesn't serve any modern day purpose, which I think is not correct. So the second form of restriction against barriers to trade is the standalone provisions that explicitly prohibit certain forms of interference with trade and national markets. So in addition to the jurisdictional restrictions, you also have standalone provisions. We've already talked about one of them. Section 121 of the Constitution Act 1867 requires free trade in goods. There's at least one other provision that's worthy of mention, though. Section 6 of the Charter, much more recent in origin, obviously, but it protects interprovincial mobility, including the right of Canadian citizens to earn a livelihood in any province. Sadly, both of these provisions, both Section 121 and Section 6 of the Charter, have been given a diminished interpretation by a Supreme Court that lacks an appreciation for the economic vision of the Constitution. I've already mentioned what the court did to Section 121 in the Como case. The court interpreted the provision such that it offers no meaningful protection beyond what the division of powers already provides. If a measure is within provincial jurisdiction under a flexible approach to federalism, it is all but certain to be upheld under the court's permissive approach to Section 121. In a separate 1997 case called Canadian Egg Marketing Agency and Richardson, the court had previously given a limited reading to the Section 6 labor mobility protections in the Charter. The court held that that provision, Section 6, was not designed to further the economic union of the country. A remarkable and deeply misguided holding that I think was inconsistent with the court's own previous precedent up to that point on Section 6. To my mind, the court's biggest problem is that they just don't understand how these disparate constitutional provisions relate to a coherent vision of the economy. While it was initially enacted in 1867, the Constitution reflects an economic vision that still resonates today. That vision starts with a presumption in favor of decentralized decision-making through two separate mechanisms: secure property rights and decentralized governance autonomy. Decentralization is highly significant to economic decision-making. Property rights enable owners to take advantage of decentralized information, local information relevant to economic decisions. And local governments are similarly able to take advantage of local knowledge about circumstances, priorities, and values that may be particular to different parts of the country. This is vital to the governance of a large and diverse country like Canada. And it can be extended to include communities that were initially left out of the constitutional settlement in 1867. Both property rights and governance jurisdiction can be important for enabling local decision-making by Indigenous communities, for instance. At the same time, though, the Constitution provides for economic integration and free trade. Despite the commitment to local autonomy, the Constitution allows for exceptional federal jurisdiction on a limited set of subjects, on which local decision-making is unlikely to be effective. The Constitution also restricts the power of governments, primarily provincial and local governments, restricts their ability to interfere with the flow of trade. And here the Constitution is most clearly grounded in enduring principles of political economy. The federal government is better positioned to enact policies for interjurisdictional economic relations that reflect the interests of the country as a whole rather than one province. At the same time, provincial and local governments quite simply have incentives that tend to lead them to impede the flow of trade in order to favor local interests. In the absence of some kind of institutional response, there would be an important collective action problem. Constitutional restrictions on barriers to trade are a kind of commitment mechanism that ties the hands of provincial governments in order to bring about a state of affairs in which they're all likely to be better off. That was as true in 1867 as it is today. We just have a larger, much larger, and more diverse country than we did in 1867, in a way making the challenge all the more urgent. So that's it. I've tried to set out the basic features of the economic vision of the Constitution, why that vision matters and why it's a problem that we've begun to lose touch with it, especially in legal and policy circles. As I mentioned before, I am in the late stages of writing a book on some of these ideas called Trade and Commerce, Canada's Economic Constitution. It should be out next year with McGill Queen's University Press, so watch out for it. And with that, I'd love to take your questions.
Wonderful. Thanks very much, Malcolm. That was great. And I wish that we were in person in a classroom so we could thank you with some applause, but I'm sure some people are silently clapping in their basements or offices. And that was great talk. I got a couple of questions coming in. I will encourage those of you who have questions, haven't submitted them yet, to post them in the chat or message me privately through the Zoom platform if you prefer. I'm going to start out with a question of my own. I'm not trained in the law, so I'm generally not someone who's watching Supreme Court cases. The Como case was an exception for me, and I expect it was for other people who are here too. And a lot of us, and this might include you, were hopeful that perhaps the Como case was going to end up differently. Is there any chance that there is another case that sort of the court would hear that might change things on that? Or is this sort of a once in every 1 or 2 generations sorts of things that it's now settled for the foreseeable future at least?
That's an interesting question. So one of the sort of fortunate things for people who don't like an outcome in a Supreme Court case is that the Supreme Court has taken an increasingly relaxed approach to its own precedents, to following its own precedents. And so it's fair to say that nothing is quite settled in the way that it perhaps would have been in the past. I do think that there's some room for sort of elaboration in Como, on sort of a standard in Como. And so you did have a case, at least at the trial level, where after Como, parties were successful rather in challenging a provincial measure for impeding interprovincial trade. That was the steam whistle case. And that was based on sort of this idea of, well, the primary purpose of a measure, and that involved, I should say, beer markups that were in a sort of complicated way made to burden out-of-province brewers more so than in-province brewers. And there you had a particularly fortuitous set of facts because you had, government decision makers essentially saying that we're doing this to favor local producers. And there is a line in Como that says that that's not allowed. If that's the only purpose for what you're doing, and it's not part of a larger regime, otherwise within provincial jurisdiction, then that's not allowed under Section 121. So if the only reason you're doing something is to favor local producers at the expense of outsiders, that does. I mean, there are measures like that where if a court is taking a realistic view of the purpose of the measure, it's primarily about local protectionism. The court did say that you can't do that. If I were to sort of point to where the sort of likelihood of an improved outcome would be, it would probably be in a consideration of the intersection between Section 121 and the division of powers. And so from my mind, what the court was concerned about in Como, at least some of the members. So it was a unanimous decision, we should say. And I think it ended up being, in terms of the politics of the court, I think it was probably an alliance between people who sort of didn't necessarily like the policy outcome of restricting provinces' ability to create barriers to trade, an alliance between them and other members of the court who were more concerned about doctrinal consistency and not undermining established precedents indirectly. And what I mean by that is that they didn't want to create additional restrictions beyond what the division of powers already allowed for. The problem is they adopted a really permissive approach. So they said that basically, as long as it's part of a broader regime, it's rationally connected to that regime, it's allowable. There's actually some ambiguity as to whether that is the right standard for all kinds of provincial measures in terms of just the division of powers. For some significant intrusions into federal jurisdiction, it's arguably the case that you need a more robust standard, namely whether the measure is necessary to achieve the provincial objective. And so I think that if we were to sort of try to push against barriers to trade in further litigation, it would probably not be directly under Section 121. It would be to try and revive a more robust understanding of the division of powers and the limits on provincial measures that are part of a broader regime, but that also significantly burden interprovincial trade. So the limits on provincial jurisdiction under Section 92.
Well, thanks. There's a second question actually that also deals with the local protection issue. I'm going to skip ahead to that because you mentioned that during your answer there. You've sort of weighed in on the legal aspect of local protectionism, whether that's allowed, but I know you've studied economics and political science, so I'm going to give you a chance to weigh in on this one. Someone asks, do you think that there could be a benefit to this local protectionism in the short term? For example, taxing goods coming into the province to allow as an industry within that province to grow. Could taxing beer coming into a province allow the brewing industry in that province to develop and lead to more brands and styles for consumers?
Mm-hmm. Yeah, so I mean, it's an argument that you can make. I think the sort of first answer I would say is that the Constitution commits us to another set of principles, which is that that kind of protectionism isn't allowed. In terms of, in policy terms, I think that there are sort of counter arguments to that approach, which is that it's possible that with respect to some industries, that sort of thing might happen. The problem is that when you leave it up to local governments to decide what industries they're going to protect, for sort of reasons of the sort of political economy within a province, they're likely to exaggerate the benefits of protectionism and underestimate the costs, right? So even if you acknowledge that that could work some of the time, sort of infant industries, protecting an infant industry until it grows up, there's the problem that there's these political incentives for provinces to do that all the time and to never take away those restrictions, because you're going to have local producers who are effective lobbyists for their interests, and you might be burdening consumers, but the effects on consumers are diffuse, they're not well organized, and you might be burdening out of province producers, but the provincial government might not really care what other province producers say, because the interests there, the jobs, et cetera, are in other provinces, and the sort of incentives of the political system are for them to favor in-province industries. So I would say that even if that works some of the time in some industries, the decision-making is unlikely to be to reflect that ideal, that you're likely to have provinces taking sort of an exaggerated view of the benefits of these things, and allowing a situation where they never remove, say, the protections for the developing industry.
Great, thanks. And for anyone who hasn't read Frederick Bastiat's petition from the candle makers, I think this really sets out these sort of arguments that are made for industrial protection of domestic industries in a really satirical way, but it's very readable despite the fact that it's now almost 200 years old. Next question, we're going to switch gears completely here. Given the Supreme Court's decisions on the right to collective bargaining under the Charter, would it be impossible for a Canadian province to pass an American-style right-to-work law?
Yeah, that wasn't really within the scope of what I'm talking about here, but there's I think at least a a strong argument that such a law would run afoul of the freedom of association as it's been interpreted by the Supreme Court of Canada. And I'm talking primarily about how there's been the court has lost touch with this sort of classical constitutional vision of the of our sort of system of government. That's not to say that they haven't been developing, or at least some members of the court adhering to alternative visions of how the economy should be structured, favoring, say, social democratic principles, the idea of collective bargaining and unionization as being particularly important, and so you sort of stretch the meaning of freedom of association to include affirmative protections for collective bargaining. I think another sort of aspect of the emerging economic vision, or the alternative economic vision, would be this idea that for most forms of government regulation, we want to get out of the way, take a flexible approach, that we want to allow for, in every respect possible, economic decision-making by governments in their conception of the public interest, except when it runs into other protected interests that they think are important, like collective bargaining. So I think just on that question, would right to work laws be unconstitutional as the Supreme Court of Canada has interpreted freedom of association? I think there's a pretty good argument that at least this court would find it to be unconstitutional. Yeah.
Great, thanks. I know this next question comes from a philosopher, so he's going to be asking you to dig deep on some of the thinking behind some of the court's opinions. Could you speak a bit more on the driving jurisprudential commitments that make it possible to view the Constitution as silent on economic issues? Given that the interpretive change is, as you say, relatively new, what strong interpretive principles make it possible for the court to take this view?
Yeah, I mean, I think part of what's going on is you're talking about provisions that have been interpreted and reinterpreted over the course of more than 150 years at this point. And so you're looking less immediately to the text. I think it's fair to say the text is just, as I said, clear to the point of redundancy in stating that the say jurisdiction's exclusive, and part of the reason for that, I think, is that it restricts, for instance, provincial protectionism. So, I think part of what's happened is that you're sort of you're looking less immediately to the text, and it is, to be fair, it is something that was perhaps unanticipated to some degree by the framers. The fact that you would need some jurisdictional overlap. This idea that you're going to have complete watertight compartments. I think it is the case that is not practically possible, and that's something that maybe emerged through the jurisprudence and sort of this legitimate recognition of things that have, say, a double aspect. The same set of issues could be under both a federal head of power as well as a provincial head of power. And over time, those sorts of things were recognized. And I think that's appropriate. I think, constitutional interpretation does have to be pragmatic to some degree. The problem is, I think, that there's been sort of an exaggeration of that you have the recognition that there are such things as double aspects. There are instances where, for practical reasons, we need to allow some degree of intrusion in a federal scheme onto provincial jurisdiction and vice versa. I think that once you recognize that, they failed to properly understand the necessary limits for that and the important justifications for policing those limits. And some of those justifications are economic.
All right, thanks. Our next question comes from someone who's in Alberta, like you, and I think separation discussions are on their mind. He says, I wonder, how do you propose that Section 121 could be read more broadly without undermining exclusive provincial authority? Is this the type of problem that led to sort of a Brexit situation and might feed into separatism in Canada?
Well, I think there's a way to recognize, to sort of interpret Section 121 to include a robust sort of set of restraints against barriers to trade, while at the same time being true to at least a classical understanding of the scope of provincial jurisdiction. And that's partly what I'm trying to do here, is to say that these things lead in the same direction. We should be policing federal intrusions into provincial jurisdictions just as much as we should be policing things the other way around. On the one hand, you might be saying, yeah, that we're going to limit the ability of provinces to regulate interprovincial trade in certain respects, but at the same time, we're going to be vigilant in, say, policing federal intrusions into powers over natural resources or property and civil rights. And so, what you lose if you sort of adhere to that, something closer, watertight compartments maybe isn't the right way to think about it. Maybe we should be thinking in terms of water resistant compartments, something, not quite this sort of absolute conception. And if you do that, what you lose potentially in your ability to regulate interprovincial trade, maybe you gain in terms of more robust protections against federal intrusions onto private law. Or natural resources. And so I don't know if there's like a net loss of provincial autonomy that we'd be talking about here. I think, as I sort of emphasize, decentralization of economic decision making and local autonomy are important components of the economic vision.
Right. As I think it was Thomas Sowell who said, there are no solutions, only trade-offs.
Yeah.
That might apply there. So our next questioner says that many people they know are in favor of centralization, and they see it as enabling the federal government to enact policy that might otherwise be blocked by areas of the country that are out of step with the majority, and perhaps even out of step with right thinking. And I can't help but think many of us in Ontario might know people who think that Alberta is this area of the country that is out of step with the rest of the country. And he says, indeed, one example would be related to carbon emissions. So if you were talking to someone like that, how would you present the case in favor of protecting decentralization when they're worried that it's going to be used to stop something that most of us think should be done?
Yeah. So, I mean, I think there's a trade-off, there's a balance to be drawn here. If you're, there are matters that are legitimately under federal jurisdiction, and there are also effectively residual powers that allow for the recognition of new heads of federal jurisdiction. And those obviously, because of their potentially significant impact on provincial jurisdiction, those have to be dealt with carefully. I'm speaking primarily about the peace, order, and good government power, but the federal general trade and commerce power operates somewhat similarly as a kind of highly abstract federal power that allows for the recognition of areas of federal jurisdiction over the economy. And there's a thoughtful way in which the Constitution makes this trade-off. So one of the sort of categories of federal power that I didn't talk much about is areas where activity in one province has direct and immediate impacts on other provinces. And so in terms of enumerated powers, the activity that probably most resembles that is fisheries. So you have, federal jurisdiction over fisheries in part because fish move around. And if you had provincial jurisdiction over fisheries, you would have kind of a collective action problem potentially. The decisions made in one jurisdiction would have a direct impact on others. And that sort of extra provincial effects idea has also been taken up under the recognition of new heads of power under peace, order, and good government. And part of the dispute in the carbon tax case was the extent to which that line of reasoning justified federal jurisdiction to some degree over carbon emissions. And there's a debate about how far reaching that jurisdiction should be if it is recognized. But those sorts of matters where a decision made in one province either directly or indirectly has a significant impact on others, either say provincial protectionism, that's what I was talking about, or other kinds of decisions where you have an immediate effect on others. Well, that's the kind of thing where at least there's a good argument that we should be making that decision together, and that other provinces shouldn't be allowed to do things that directly affect one province shouldn't be allowed to do things that directly affect another. But on other issues where most of the effects are within the province. Any effects on outsiders are negligible. I think another set of arguments tend to prevail, which is that it may very well be that different solutions apply in different provinces, that sort of local circumstances, local values, local priorities are different, and so legitimately would justify other different approaches. There's also the idea of local experimentation, this idea that maybe one jurisdiction will figure out a solution to something that turns out to be useful for others to follow, and it wouldn't have emerged if you had sort of a rigid centralization. There are interesting examples of this. One of the ones that I'm sort of fascinated by is British Columbia in the area of the administration of justice has established the Civil Resolution Tribunal, almost entirely online dispute resolution channel for small claims disputes, and they keep increasing the jurisdiction of it. And in a time where in Canada we have really significant problems for the civil the operation of the civil justice system, that kind of local innovation is something to watch, and it's great that provincial authority over the administration of justice has allowed for that kind of experimentation. Now there are downsides, there are critics of it, but that kind of local experimentation could yield a useful model to be followed elsewhere. So those are the primary arguments I think we'd have in favor of decentralization. I understand that there are limits, and some of those limits are reflected in the Constitution's federal heads of power.
Right, thanks. And I think this is actually really interesting for those who attend last week's talk on the ideas of Eleanor Ostrom. There's a lot of interesting overlaps between this sort of polycentricity that you're talking about and that Jamie Lemke discussed last week. There's another question on the carbon emissions, but I think you pretty much covered it during your answer to that first question. I'm going to skip that. I've got one more in the queue, and we probably do have time for one more after that. So if anyone's been holding a question and wants to get it in, you can pop that in quickly. But for the next one, this questioner says, underlying Justice Rowe's concern, underlying Justice Rowe's question was the concern that if economic policy is constitutionalized, then that excludes people who disagree with the judiciary's economic vision from pursuing their goals in the political process. If you constitutionalize libertarian economics, doesn't that exclude social democrats from the regime and vice versa in relation to Section 2D?
Yeah. So that is basically the outlook that the court ended up endorsing. And I think there was another point in the hearing. I think this question was from Gareth Morley, wasn't it? Who was also counsel in the Como case for BC, I believe. And then this also came up in the hearing, this idea that I think it was maybe Justice Brown, I hope I'm not misremembering, who said basically, if you want to enact these policies, go down the street, don't come to the court, go down to the street to Parliament and or to your provincial legislature and enact these policies. And I think that the best answer to that is that there's a structural problem with the political process on issues like this, which is that the problem of unrepresented outsiders that I was sort of emphasizing. This idea that in cases where policy making in one jurisdiction affects people in other jurisdictions in immediate ways, say a provincial protectionist measure, that's a flaw in the political system, right? That's people who are being impacted by a policy who have no say in its enactment. And that's the exact kind of argument that would potentially, and this is an idea that's existed in constitutional theory for a while. It justifies not only these kinds of restrictions against protectionism, it also provides a justification for certain kinds of protections for fundamental freedoms, right? This idea that certain kinds of minorities, the political system is likely to fail them because their viewpoint won't be adequately representative in political decision making, and so you need to protect their interests by restricting what outcomes the political system allows for. I think an analogous kind of argument applies when you're talking about protectionist measures within a federation. you have one local jurisdiction, choosing to have an impact on people in other jurisdictions. And that shouldn't be unlimited. I don't think that kind of power should be unlimited. There's a balance to be drawn. And if you're pursuing an important policy within the province and what you're doing in terms of burdening trade is somehow necessary for that policy, maybe it should be allowed. We can have a test that allows for that kind of thing. But sort of unrestricted power on the part of the sort of political system in one jurisdiction to affect others, I think there's a pretty solid argument, even from a democratic point of view, why we ought to limit that, in addition to the fact that the Constitution sort of says we're limiting it.
Great, thanks. We're coming up on our time, so we're going to, sorry, we're going to wrap up there. I want to thank you, Malcolm, for a great talk. I want to thank all of you for joining us. Like many of us, I know you spend a lot of time on Zoom these days, so we're grateful that you were able to find time in your schedule for another meeting. And I hope you felt it was well worth your time. I certainly thought it was a great talk. We'll look forward to Malcolm's upcoming book, and perhaps when that is released, we can either have you back to give a talk or back on our podcast, and perhaps even both. I think that will be great. I will mention just in closing that we will be back next Friday with a talk with William Easterly, a development economist from New York University. He's going to be about to release the second edition of his book, The Tyranny of Experts. Because it's a book release, we're going to have 12 books to give away next week. So you will have some pretty good odds depending on how many people show up. And also Bill Easterly's a really interesting thinker, and I think that will be a really interesting discussion. So if you have not entered this week's book draw, you still have a couple minutes to do so. We will be sending out a copy of Canada's Founding Debates to one of you here. And if you don't win, please consider checking that book out on your own time, either from the library or ordering it online. Thanks again to all of you. Big thanks to Malcolm for joining us. It was really great. And I hope to see many of you back here next week. Take care, everyone.
Thanks.